Supreme Court of Appeals now said that all persons having motions to make appeals to the prosecutor come forward and shall be heard. God save the state of West Virginia and this honorable court.
All right, we will begin the oral arguments this morning under Rule 20. The first case for oral argument is In Re B.A., docket number 19-0921, an appeal from the Circuit Court of Wood County, West Virginia. And although Justice Workman is not here in the courtroom today, she will be listening and viewing this oral argument through our webcast, and so she will be participating in the decision and opinion of this case. I'll remind counsel that each side has 20 minutes to present your oral argument, and we have added a little clock right next to the podium so that you can keep track of the time of your argument, and the respondents do need to split your argument time. It would be helpful to the court if the first respondent arguing would let the court know how you're splitting your time. With that, counsel for the petitioner may proceed.
Good morning. Before we do, just you may go ahead and come to the podium, but we have appropriate social distancing measures here on the bench, as well as at the podium. So that's fine. Everybody does that. And so I do invite the other justices to remove their masks as they discuss the cases, and you as well as counsel, as you're speaking, if you're comfortable removing your mask, that's fine. If you'd rather leave your mask on, that's fine as well. You may proceed.
May it please the court, Chief Justice Armstead. My name is William Summers. I'm from Wood County, West Virginia, and I'm here today to represent the appellants in this matter, who are the former foster parents and prospective adoptive parents of the child in this matter. The one thing that I remember the most about reviewing this case and preparing for it is this Supreme Court's ruling in a couple different cases. One of them is State versus Treadway versus McCoy, where in syllabus point 2, this Supreme Court said, the best interests of a child are served by preserving the important relationships in the child's life. And in addition, it's the In Re Jonathan G. case, where this court said a child has the right to continued association with individuals with whom he has formed a close emotional bond, including foster parents, provided that a determination is made that such continuation is in the best interest of the child. And that's syllabus point 11 from the Jonathan G. case. This matter arose in Wood County Circuit Court in an abuse and neglect petition, alleging basically a lot of different circumstances, including substance abuse. The appellants are the foster placement for the minor child, or former foster placement. The minor child was placed in that home in large part because his full-blooded sister was in that home, of the same mother and father as his sibling. The petitioners picked this child up from the hospital on October 8th of 2018 due to the child remained in the hospital after birth for a short period of time because the mother was on methamphetamines and heroin. By all intents and purposes, and by any account in this case, they did a fantastic job of caring for the child. There were never any complaints about that. The department completed an evaluation of the petitioner's home in March of 2019, and that evaluation deemed the home to be safe, and that this issue has nothing to do with the health, the safety, or the welfare of the child. And according to all recent home studies and all past home studies, the home would be potentially eligible for further foster placements, although it's my understanding because of this removal, the department is not allowing further foster placements in the appellant's home. The guardian ad litem objected to this foster placement and requested that the child be removed prior to the adoption proceeding happening. The court held a hearing and by order dated September 5th, 2019, removed this child. And it's this from what the petitioners appeal of, this order. It was necessary for this child to remain in the hospital due to the methamphetamines and heroin abuse. The child was placed with his full-blooded sister. The child remained with the petitioner since his discharge until that hearing. There was a permanency hearing that was held on September 9th, which is the order that we're appealing from. And in that hearing, as I stated before, the circuit court deemed that the parents were not of good moral character for an adoption due to, in large part, gambling income that the father had, and a large unpaid child support obligation, and several different civil and criminal issues arising out of the father's construction business. We believe, the appellants believe, that the court erred in its removal of the minor child from this foster placement because they had cared for this child since birth, after birth when the child was released from the hospital, and until the time that the child was removed. The entire time they cared for this child was bonded to the foster placement and the siblings there. There were actually three other siblings there. Two of them were the biological children of the mother, one of them of the father, and one of them adopted. This foster placement was approved up until that time by the adoption. And we believe that the circuit court relied far too much on the obvious moral character issue when you look at the transcript and you look at the order. One of the really interesting cases that this court has decided on a moral character issue is State ex rel. Kuttel and Hess versus Blake. It's a 2009 case. It came out of a writ of prohibition, and in that the case was a case where it's weird to even talk about this now, but it was a case where the guardian ad litem actually was making a motion to remove the child because he felt that the circumstances of the parents being homosexual would be not of good moral character. The DHHR and the foster parents filed responses and objected to the motion, and the court said, no, we're going to leave the foster parent where it is. That's obviously a wrong interpretation, but too much interpretation, too much emphasis on the argument that there's not moral character in the home. And that's what we have here. We were really perplexed when we got the guardian ad litem's report when it went into all of these different issues and things because they'd never been issues before. And I had represented the foster parents throughout these proceedings. And then we get this report that shows that he has gambling income and that he has this child support judgment, and that there are some criminal and civil actions against him and judgments against him.
And I have a question about that.
Yes, ma'am.
First, a couple of questions just to clear up things in the record in this case. What's the current status of the felony charge pending against the petitioner?
The current status of the felony charge is that it's still pending. I think they're in negotiations on that case.
Okay.
We had thought that there was going to be, I'm not representing him in that case, but another attorney is, but we had thought that there was going to be a resolution to it recently, but apparently it is still, the last time I checked with my client, it is still pending.
Thank you for that. And then I have another question is for clarification, because I think there's a little bit of confusion in the record. The petitioner is the legal father of the child for whom he owed child support. That's correct, right?
Legally, yes.
Okay.
It is never, that was one of the contentions in the hearing, that he was actually not the father of that child, but for all intents and purposes, legally, he was the father of the child. There was some argument that was made, and it was interesting at the hearing, because at that hearing, we weren't allowed to present evidence. We were only allowed to argue. There was some argument at the hearing and proffer by me that that child actually wasn't his biological child, but we didn't have anybody there to be able to testify or to prove that because we couldn't put on any evidence. But at any rate.
Counsel, what does
Yes.
the record show about the truthfulness or lack thereof of the completion of the home study when petitioner fails to list the 3 biological children? What is the explanation for not being honest on the home study packet?
Not listing the 3 biological children?
Yes.
I'm sure that would had to have been an oversight on the part, because they have those children, and I mean, they are there. So it's not like those children weren't there and in part of the whole process. I mean, that for them not to put that on there can be troubling, I guess, to the court, but at the same time, I think it seems to me much of an oversight, and because everybody knew that those children were there in the home. The three biological children were there in the home. That was never an issue.
Thank you.
You're welcome.
Counsel,
Yes, sir.
question about going back to Justice Walker's question about the child support and the failure to pay child support for a child that he's the father of. It's clear that there's little case law really in West Virginia about that issue and whether that constitutes good or good moral character in terms of this particular situation, but in terms of actual adoption, in terms of such things as immigration law, different things like that, that there is some case law about the fact of when moral character is required, that the failure to pay and to support a child financially is indicative of a failure of good moral character. So I just would like your response. You're asking us to reverse the circuit court's determination that being a large part of their determination that there was not good moral character here. And I would be interested in your argument as to why the failure to support a child in this case would not indicate the failure of good moral character.
Well, I think the best answer that I have to that problem, because it isn't a good thing when you don't pay your child support. I mean, everybody knows that. But at the same time, I think that courts should look at that on a case-by-case basis to determine what the reason was for not paying the child support. Because in this particular case, the allegation was, on behalf of my client, that was proffered, that never really got into the record, was that he and the mother knew that that wasn't his biological child, so they didn't follow through with paying the child support, that was some kind of tacit agreement that they had. So while on the one hand, taking it right from the record and saying, yes, he had a legal obligation to pay it and he didn't do it, could on first blush looking at it be something that would be a moral character issue. I think that it would be more prudent for, on a case-by-case basis, to ask questions about why that happened. You know, did he have horrible financial situations? Was he sick? Was he injured? Was he not able to work because he had a horrible car accident? And I mean, there could be some things that might make a person not be able to make their child support obligation. But I mean, generally speaking, they need to pay it. But at the same time, there might be something that would prevent them from paying it, or some tacit agreement like they had allegedly in this case.
Other than as you said, tacit agreement, what other evidence is there in the record that justifies his failure to pay, in your opinion?
Well, there was no. We weren't able to put on evidence in that hearing, so there is really no evidence as to why that happened that the court can look at, because we weren't allowed to put on evidence in that hearing. There was and I can't remember the case that the judge cited, but I know the case that said that the foster parents are allowed to participate in the hearing, but they're not allowed in as a party to the hearing to present evidence, and unless they actually make a motion to intervene, which hadn't been done. So,
is there any evidence in the record of attempts by the mother of the child or children that were the basis of the child support order? Is there any evidence in the record of any attempts to collect that? Is there any evidence of decretal judgments, anything like that?
no, Your Honor, there is none.
All right, thank you.
What can you share with us about the default judgment on failure to pay babysitting services?
It's my understanding that that was paid and taken care of.
Okay.
Because they did go, after all these judgments came up, they did go around and try to pay the ones that they could pay off. They were the one big one outstanding that is the part of the criminal case that's actually not a judgment, but that was the one big one that they hadn't been able to pay off. But I think they went around and paid most of these judgments off.
What do you think that goes to the issue of good moral character that, as you said, when this came up, they went around and paid off those that they could? It's the fact that they got into the trouble in the first place and the failure to pay for those services, you know, this is child care services in particular. I guess that's the question. I kind of look at all of these. You've got those relating to gambling and all that you might characterize as not relating to the moral character relating. Obviously, my questions are focused on the issues of defaulting of babysitting services and the filling out the case plan. So, any explanation about the default on the babysitting services?
I think that was, from my understanding, that was a misunderstanding between the babysitter and them, and she went down and filed it, and then they paid it off as soon as they were aware that it happened. So, I have maybe somewhat of a unique perspective because I've represented quite a few contractors like him, and it's really not uncommon for contractors to be sued And so I think that without a more in-depth explanation, a more in-depth analysis of why those judgments were there or why the contractor was sued or even had a false pretenses case like this one in this case, I think there really needs to be some more in-depth analysis, because it's very common for people when they get upset with contractors or they get upset with someone who's building their house to file lawsuits or go and try to file something or get the police involved with it and say that they've stolen money from them. All the way back when I started doing criminal appointed work in the first part of my practice, I would get cases like that where a contractor was sued for false pretenses. So I don't know if that's necessarily on its face a moral character issue just because it's there.
And I know obviously you have strong feelings relating to the conduct of the guardian. There was a disciplinary complaint filed against the guardian. What was the disposition of that?
The disposition was that that they didn't find any kind of wrongdoing. It's my understanding. They dismissed it.
Okay, thank you.
Any other questions? Okay. I was beginning to get into my second argument, which was the separation of siblings. So we first dealt with the good moral character argument, but when a child there's a code section on this, it deals with it. It's 49.214, lowercase parentheses e. And that code section says that separation of siblings, and I think it's all through our case law, that separation of siblings is never a good idea. The code section says if the department is of the opinion based upon available evidence that residing in the same home would have a harmful physical, mental, or psychological effect on one or more of the sibling children, or if the child has a physical or mental disability where the existing foster home can better accommodate, or if the department can document that the reunification of siblings is not in the best interest of one or all of the children. And I don't really think that analysis was ever done here. I don't think that there was an analysis as to whether or not there was a harmful mental, physical, or psychological effect. In fact, the evidence is really to the contrary. The child was well cared for all the way through to September of 2019. The second would be if there's another foster home that could better accommodate the mental disabilities of the child or physical disabilities of the child, and that was never even explored. And then third, if for some reason it would not be in the best interest of one or all of the children. And again, that gets back to the other argument that the best interest standard here, the court focused mainly on that financial issue and those financial issues, the gambling income on the tax return, the fact that there were child support obligations not paid, the fact that there were judgments and pending lawsuits. And I think the court sidestepped all the other important things, like that these people were good parents, that these people had raised this child from the beginning of its birth, that they took care of its health problems. There was a time when they took the child to the hospital to get ear tubes in its ears to Columbus. I mean, they did everything that parents should have done and foster parents should have done in these cases. So it was, the guardian ad litem issue. It was a little bit shocking as to why it happened, which is why I put the argument in that I did, because the foster parents were very upset that the guardian hadn't come out and seen the kid, and so they did what they did. And so we almost felt like that it was retaliatory, because there's been no complaints at all from the beginning of the case about them, and then all of a sudden, boom, this thing comes up about their finances. It was almost like the perception, the smell test, the litmus test was it just didn't seem right, because they had done everything that they were supposed to do, and then when they complained, they got this bad guardian ad litem report. There was a lot of unnecessary scrutiny on the appellants in this case, we felt, especially with the gambling income. I mentioned it, I think, when one of the justices was asking me a question, but to focus in on gambling income as an immoral activity, I mean, it's a legal activity in the state of West Virginia, and I think a good part of the state's budget is derived from income from gambling. So I don't think that that's a very good analysis to use. And it's almost, it goes back to the case that I cited, and which is why I don't think the moral character argument is it should be given as much weight, because it goes back to the case that I cited, the Kudel and Hess versus Blake case from 2019. To that guardian ad litem, being homosexual was not something that was morally, was of good moral character, and he wanted to remove the kids from the home. So this guardian ad litem wanted to remove the kids from the home because she felt that gambling wasn't a good moral character, that judgments were not of good moral character, that other things were not of good moral character. And how do you draw the line as to what's good moral character? That's a very difficult argument to make. So I think that courts shouldn't put so much emphasis, and I don't know how you draft an opinion if you believe me, but courts should not put so much emphasis on moral character because that's so subjective to the person that's looking at the situation.
Counsel, you have only about a minute or so left, so if you wish to
All right.
have any rebuttal, or would just ask you.
I'll reserve for rebuttal. Thank you.
All right, thank you.
Take your little microphone thing.
All right, now hear from the respondents again. This will be worked out how you want to share your time. I don't know if, is anyone present for the intervener?
They have not arrived yet.
Okay. All right. Thank you.
I think what we've worked out is I'll take about 12 minutes.
Thank you.
Thank you. Good morning, Your Honors, and may it please the Court. Thomas Lampman, Assistant Solicitor General on behalf of the Department of Health and Human Resources. There are 3 points I'd like to address, Your Honors. First, I'd like to briefly address a threshold jurisdictional question that relates to this appeal and to similar appeals. Second, I would like to address the merits of how the Circuit Court used petitioner's financial information in this case before finally turning to the resolution that will ultimately serve the best interests of the child as it stands today. On a jurisdictional note, it's important to note that, as petitioner acknowledged, the foster family in this case did not intervene in the Circuit Court proceeding below. They were not a party to the Circuit Court proceeding below, and so they cannot bring an appeal that is within the jurisdiction of this court. The West Virginia Code is very clear. Section 5851 sets forth that a party to a proceeding brings an appeal. And this court has considered this factor specifically as it relates to foster parents in the case In re Harley C. It's 203 West Virginia 594. In that case, this court addressed whether foster families can bring an appeal before this court, and this court held that specifically because those foster parents had intervened in the Circuit Court, they were a party and therefore could bring an appeal. But the right to intervene for foster parents is not guaranteed. It's a matter of jurisdiction for the Circuit Court to decide if requested by the foster family. The Department does not take a position on whether intervention would have been appropriate if it had been sought in this case. The issue is that it was not sought. And because the foster parents were not a party, they were not positioned to bring an appeal that, again, is within this court's jurisdiction. Barring any questions on that point, I will turn to the merits of the Circuit Court's decision and the merits of petitioner's argument. If this court proceeds to the merits, it should conclude that the Circuit Court was correct to examine petitioner's financial information and that the Circuit Court drew a reasonable conclusion from that information. The Department does acknowledge that in this case it is appropriate and would be preferable to remand this matter for a more specific finding on the issue of sibling preference. But remand is appropriate, or dismissal is appropriate, because as it stands today, maintaining the child's current placement is what is in his best interests. This child should not be moved back and forth between placements, and his current placement is far more likely to fulfill his ultimate permanency plan and lead to an adoption. So his best interests would be harmed if this matter were simply reversed.
So there is nothing in the record to indicate that the court gave any consideration to the sibling preference.
Yes, Your Honor. Nothing in the order.
You would agree it's, it really, and so we have our language in Ray Carroll B to deal with, which places a fairly high burden on consideration of this sibling preference. How do we just get around that? And I understand your argument. Ultimately, we're talking about the best interests of the child. But how do we? How would you propose that we overlook that?
I would not propose, Your Honor, that we overlook that. And I would point to similar cases dealing with other factors like sibling preference, factors where it is mandatory for the circuit court to consider them, but where they are not ultimately dispositive of what is in the best interest of the child. There's a variety of examples, but one I'll point to in particular is In re CB and AB. It's case number 18-0324 that dealt with the question of the wishes of a child who's over the age of 14. Those children of that age are allowed to express a preference that dictates what their placements will be, and the circuit court did not consider that. So as we are faced with in this case, there's a question of a mandatory factor that is not dispositive by itself of the best interest of the child. The appropriate remedy there is to remand to weigh that factor against the best interest of the child. At the time the circuit court was making its determination, sibling preference would not necessarily have overridden the need to develop a permanent placement that could lead to adoption. That was the basis for the good moral character finding that the court ultimately made. But as it stands now, we're talking about a child that is, by all accounts, other parties can speak to this in more detail, but a child that is, by all accounts, thriving in his current placement, a placement that is likely to fulfill his permanency plan and lead to adoption, which it is unlikely that petitioner's placement could. And most importantly, we're talking about a placement that this child has been in not only longer than he was placed with petitioner, but a placement that he's been in for more than half of his life.
The other half was with the petitioner.
Yes, Your Honor.
Right.
But as this court has emphasized time and again, and as the petitioner has fairly pointed out, the children, and in particular the most vulnerable children that find themselves in these positions, have a paramount need for permanency, security, and stability. And when, again, we're talking about a child who has been with his current placement the majority of his life, the most current portion of his life, any attachment he would have formed to his siblings would necessarily be outweighed by the attachment he would have formed to his current placement, if we're just talking about length of time. So again, because this is sibling preference is not a dispositive factor, simply reversing on that basis would not account for the balancing that we need to conduct based on circumstances as they exist today and what would be in BA's best interests today. The circuit court can be directed to consider these factors, can be directed to do a more full finding on these factors, but that would be the appropriate resolution here to get the most accurate picture of what's in BA's best interest.
Going back to your jurisdictional argument, having prepared for today, it seems that this is the first time we're hearing this argument. Am I right about that?
In this case, yes, Your Honor. There's a twofold problem we're faced with where a non-party foster parent bringing an appeal is procedurally unusual, but at the same time it's becoming more common as a practical matter. And I would point to a motion to dismiss filed by the department just on Monday in case 20-0506, articulating essentially the same arguments I've set forth today. This is a situation where, again, because it's procedurally uncommon but practically more common, the department needed to weigh the various concerns that go into developing a consistent position across the several cases where this comes up and where the factors that inform what approach is best in each of those cases may vary.
We've got this issue in a number of areas because, for example, we had a case yesterday where there was a grandparent seeking to have the court enforce the grandparent's preference, but because she was not a custodian and didn't have custodial responsibility at the time the petition was filed, she didn't have a right to intervene. And so how does she protect her rights in terms of the statute saying that the department must identify, grandparents and do a home study, but she has no right to intervene in the case under our current law to enforce that right. So I mean, you've got foster parents who have by statute have the right to participate in the case if they have custody, but then they're not parties for purposes of presenting evidence and doing that sort of stuff. So how do they, I mean, it seems to be a procedural catch-22. You're damned if you do, damned if you don't. And do you agree that there's some issues?
I don't agree, Your Honor, and I would point to two options that, at least in the context of foster parents, that parties could pursue. As I mentioned before, and as petitioner acknowledged, he could have sought intervener status, and there are fraught distinctions with when grandparents can be interveners versus when foster parents can be interveners. But he had every right to, in this case, to seek intervener status, become a party, potentially to appeal a decision if he was denied intervener status. The second option that he had comes from the Kutil case that petitioner mentioned. In that case, the foster parents were not interveners, were not a party to the case, but because they believed that the circuit court's decision was unlawful and was not within its authority, they sought a writ of prohibition. And that was an option that they were able to pursue, irrespective of whether they were a party to the case, because they were subject to an order that the court did not have the authority to issue. If petitioners thought that this was an unlawful order, that the circuit court should not have revoked their placement, then that potentially would have been an option. It would have been more complicated in this case because petitioners were the ones who brought the issue within the court's purview in the first place by filing a motion. But as a more general matter, as it speaks to the procedural catch-22, that would be an escape valve that foster parents who are ignored by the system rather than who are given an opportunity to bring their question before the court, those foster parents could use to come before this court and possibly get a resolution of their complaints.
Well, how do we deal with the fact that in a prior proceeding, and I believe it was in Wood County, in a prior proceeding, the court found that these folks were of good moral character and permitted the adoption of this child's sibling? How do we get around that?
That speaks to the timeline here, Your Honor. Some of these debts were incurred before that first child was adopted, but over $15,000 of these obligations, plus a defaulted land contract, were incurred after that adoption took place. And
yeah, but the main one, the failure to pay child support, was obviously incurred before the adoption of that child.
yes, Your Honor, that's true. And it's the considerations that I think play in here are never about any one debt or about any one obligation. If we were talking about just $110,000 in medical debt, that could happen to anybody. So it's not just about the amount. If we were talking about a series of debts along the lines of the $84 business and occupation tax lien, that's maybe irresponsible, but doesn't necessarily speak to moral character. As it's been mentioned, there are some factual questions that go into the nature of that child support debt. That debt in and of itself may not have been enough to find petitioners of poor moral character. It is a strong indicator, as the circuit court noted, but on its own, it's not necessarily enough. But as I mentioned, further series of business obligations were either ignored or defaulted on after that adoption took place. $30,000 of these debts were incurred as liens or as default judgments in the course of 2018 while that proceeding would have been going on, and would not necessarily have come to the attention of the court without petitioner's disclosure. I see my time is drawing to a close. I'll simply note that there is always a preference in seeking a placement that will lead to a permanent adoptive home. This is not to say that any foster family with any debts, as a bright line rule, is debarred from being a foster family, but circuit courts can prevent delay in securing a stable and permanent home for children by considering these issues when they are brought to their attention, when there is a certain threshold of moral character that's met, which I think was in this case, based on the scope and based on the pattern evinced by these debts. In those circumstances, it is appropriate for a circuit court to revoke a foster placement. So again, with that finding in mind, we would ask that this court remand for consideration of permanency versus sibling preference as the facts stand today. Thank you.
Thank you.
Guardian ad litem.
What's his last name? Yeah. Okay. I thought I heard it correctly. He's not listed on the thing. Okay.
Good morning. May it please the court, I'm Deborah Steed. I'm the guardian ad litem. And I would first like to address, if I may, good moral character, which is in West Virginia Code 4822701D. And I couldn't find any annotations that actually described good moral character in any kind of detail. So I went to Ohio and looked at their revised code, and again, I couldn't find any. But I did find in the Michigan Division of Child Welfare Licensing requirements, they actually define good moral character. And it excludes if you have conduct that constitutes bribery, fraud, filing of false claims, aiding or abetting the filing of false claims, and, of course, criminal conduct. So, with respect to the petitioners in this matter, I started an investigation into their finances, with the filing of the felony, which was brought to the DHHR's, attention. And once I found that, I just simply looked on the county clerk's websites and found all these other claims. I mean, it wasn't like I was financially investigating them, but it was public record. And when I found it, I realized that I would have to, object to the adoption based on the good moral character standing. So that's why I filed my report. That's why I requested the department moving, because he wouldn't be, they probably wouldn't meet the adoption standard. And then, thank you. Excuse me. This is my first time arguing.
Don't be nervous, you're fine.
Well,
You lucked out, we don't have a big crowd in the courtroom. because
yeah, I know, but
COVID,
of course
so-
everybody's watching, including my children. But that's okay.
She's doing a fine job.
They're just glad I'm here. And as far as the sibling preference, I knew that was going to be a problem too, but West Virginia Code Section 494-111E1 speaks to competing foster care arrangements. And in cases where there is a sibling in the home, then you also have to look at fitness, the fitness of the foster parents. Now, in Ray Carroll B, the paternal aunt and uncle and the maternal aunt and uncle were both fit. Neither family had a problem with fitness. So that part of the analysis was thrown out. And
Do you concur with the recommendation of the DHHR in this matter, which, among other things, I believe Mr. Lampin recommended that it gets sent back for a determination on the sibling preference versus the best interests of the child? Do you agree with that recommendation?
I know, because we have this fitness standard, and I think that's what's at stake here is the fitness standard, maybe the remand should be on a definition of good moral character for adoption purposes, which I couldn't find in our code.
And another question I have goes to a point the petitioner's counsel made, and that is that a contractor, for good or for ill, necessarily runs into, I don't want to paraphrase it incorrectly, so I'll just answer it my way. You could argue that a contractor can be more publicly investigated because of the nature of a contractor's work, and whereas a private citizen, I mean, do you run a credit report on every foster family?
I think that's a
because
great idea.
Well, but I'm just saying a contractor is more susceptible to this kind of scrutiny, and we may just say, well, everyone should be scrutinized. But how do you justify kind of holding someone who chooses a particular profession to more scrutiny than, say, a private citizen? And we don't talk about credit reports in these cases.
Well,
I'm not suggesting for a minute that we do, by the way. I'm just sort of teasing out a hypothetical question here.
Okay, maybe they do get scrutinized a little bit more. However, it appears the petitioner has a pattern of not paying for his work. If you read my update in January of this year, he was also sued by his supply company for like $17,000 in attorney's fees, and that has already been reduced to a judgment. And it's of record in Wood County. It was entered June the 8th. In book number 2117 at 451, if the court would take judicial notice of that. So that has already been reduced to a judgment. And as far as credit reports, I think that's a good idea for foster families, because right now all we have is the home study, which is a self-report. And in the home study in this case, there were a lot of things that were omitted from the self-report, such as the foster father had a child. He's on the birth certificate, and they tried to throw that off like it really wasn't his kid. But you're on the birth certificate. You're the father. So did I answer your question?
You absolutely did.
Okay.
Can I just ask one question, going back to sort of one of the points that the petitioner made was that, you know, the gambling issue, that's legal in West Virginia. And I was trying to see from the record whether there are allegations that there were failure to make payments for other obligations, you know, babysitting, different things of that nature. Was there anything in the record that showed that those two were connected? I mean, that I'd say perhaps gambling in and of itself is not an issue, but if it causes the other obligations to not be met, is there any evidence in the record that that was the case, to your knowledge?
There's no evidence, but if you win $16,000 in gambling income, how much have you spent? I'm sure you just don't go in one time and you win $16,000, but that's maybe getting off track here.
In the record, I'm sorry, yeah.
As far as the babysitter, to my knowledge, that has never been released. That was a default judgment, so the petitioners did not even go to the hearing. They didn't answer the complaint. They totally ignored it. It got reduced to a judgment. I don't know if he was gambling and not paying his debts, but there's nothing in the record to indicate that.
Thank you. All right. That, I think, thank you very much.
Okay.
Argument. They have a brief rebuttal from
In this particular case, I think it's interesting they bring up the jurisdictional argument, because in this particular case, there was no motion to intervene filed, but how does a foster parent know when they're supposed to file a motion to intervene? Do they file it from the beginning, and do they keep filing it as it gets denied because the court doesn't believe that they have enough standing yet to become interveners? Or do they file it when a problem arises, like happened in this case? I mean, they were good all the way through the case. They get this bad report. Then do they have to file a motion to intervene at that point in time to get any relief? I think it's too late at that point in time, because they've already had the hearing that they should have been interveners in, that they couldn't present any evidence. So, I mean, my advice from now on for anybody that comes to me as a foster parent is immediately file a motion to intervene, and we'll keep filing them until you get to intervene, because otherwise this jurisdictional argument is going to prevent you from appealing or asserting your rights. Thank you.
Thank you. All right, this case will be submitted. Thank you.
The next case for oral argument is also under Rule 20, City of Morgantown versus Calvary Baptist Church, docket number 18-1134, and this is an appeal from the Circuit Court of Monongalia County, West Virginia. I would like counsel to know that although Justice Workman is not here in the courtroom this morning, she is participating by listening and viewing the webcast, and so she will be involved in the decision and opinion in this case. And I will remind counsel that under Rule 20, you each have 20 minutes to present oral argument, so you may approach and counsel for petitioner may begin. Thank you.
Thank you, Mr. Chief Justice, and may it please the Court. My name is Ryan Simonton. I'm representing the City of Morgantown, the petitioner in this case. Before I begin, I would like to reserve 5 minutes of my time for rebuttal, if the Court would permit.
Sure.
Thank you, Your Honor. Morgantown is asking the Court, in this case, to preserve its ability to make local land use planning decisions for its residential neighborhoods through its legislative representatives and its appointed planning commission, and at the same time to preserve this Court's role in making decisions about whether the Constitution permits those zoning classifications. The Court has determined that it conducts these inquiries by using the fairly debatable standard. So under the fairly debatable standard, legislative zoning ordinances are presumed to be valid. They can only be invalidated if it is beyond any fair debate that there is no rational purpose supporting a legitimate government objective to the zoning. And the Court's decisions indicate that protecting the integrity of neighborhoods is a legitimate government purpose for zoning. So the Court has set out some rules for how it will conduct this fairly debatable inquiry. The Court considers all of the factors related to the zoning ordinance, and it considers how those factors impact the community health, safety, and welfare. It does conduct the analysis as applied to the property in question, where the challenger owns the property and is challenging the ordinance. But the effects aren't limited to that property. They allow consideration and they demand consideration of the community interest. When there are positive and negative factors to the zoning regulation, the zoning will be upheld because that is a community land use planning decision. Only if it is beyond any fair debate that the ordinance is arbitrary and has no rational relationship to a legitimate government purpose can the ordinance be invalidated. This Court has also said, regarding the fairly debatable standard, that it can be evaluated by considering objective observers. If objective observers, looking at all of these factors that have been considered as evidence, might reach different conclusions about what the zoning regulation should be, then the zoning regulation should be upheld. So this points out the fact that the Court's inquiry is not, what would the ideal zoning classification be on the record we're given? The Court defers to the community in that decision-making process. The Court's inquiry is to determine whether there has been a constitutional violation by reason of the zoning regulation. And that only occurs in exceptional cases where there can be no purpose found. In this case, Morgantown will submit that there are rational purposes for the residential zoning classification. Now, the respondent is going to tell you that there are purposes for commercial zoning in this case and promoting a commercial use. The respondent has a sales contract with a commercial developer so that it can partition a part of its church property and sell that property for $250,000. That property is also at the back of an existing mixed-use development in the B2 zoning district, and that's the City of Morgantown's service business district, which is one of the most intense business districts. And the respondent, will also say This property is on a state route, and our appraiser thinks the traffic is so high that the property has less residential value. So an objective observer could look at those pieces of evidence in the record and say, I would prefer that there be commercial zoning for this parcel. Certainly. But that is not the court's inquiry, and it was not the circuit court's inquiry. The court is to look at all of the evidence, not just the evidence supporting commercial zoning or invalidation of the ordinance. And when it finds positive factors to a zoning regulation, it will uphold the regulation. In this case, there are abundant positive factors, as well as those factors that might indicate that commercial zoning would be preferred. This is a thriving residential neighborhood. The respondent's appraiser testified that it was the most highly desirable within the city. The city has identified this as one of 2 neighborhoods within the city that are historic and that are designed for neighborhood conservation. There has been abundant new single-family construction in this 2 to 3 block area centered on Burroughs Street. The city introduced in evidence 33 building permits pulled in the past 20 years for new single-family home construction. Mr. Basio, the developer who intends to purchase the property from the church, also testified about 4 others that don't appear to be covered by those building permits. And there are 12 existing single-family homes in this same area with driveways directly accessing Burroughs Street. Finally, the respondent's appraiser testified that one of his comparable sales was a property at Burroughs and Windsor, part of this area, with frontage on Burroughs Street. So there's a robust residential market. The city's director of development services, Chris Fletcher, testified that the predominant trend in this area is residential, the predominant development trend, but also that there's an existing built environment that promotes residential uses, and that the residents of that area are entitled to the continuation of that character based on their reasonable expectations for moving into this neighborhood.
Counsel, you mentioned Mr. Fletcher, and when he testified, for the record, he talked about the comprehensive plan and said it was not law nor is it binding, it's a series of principles, I believe so. That was what was cited in the circuit court's order. So I guess I would be curious as to your belief as to how binding that document is, what is the actual nature of that document, and what is the sort of the discretion within the city to be able to zone within this area either residentially or commercially?
Yes, Your Honor. The comprehensive plan, is a law adopted by the City of Morgantown at Article 1301 of the Code, although Mr. Fletcher testified in response to respondents' counseling that it was not law nor binding in the way we normally think of laws as governing conduct. Now, cities who have zoning are required to have a comprehensive plan that guides that zoning. That's required under Chapter 8A. And so once they have that comprehensive plan, they can only make amendments to their zoning ordinance if the amendment is either consistent with the plan or if there has been a substantial change in the social, economic, or physical characteristics of the area that was not anticipated by the plan and that has changed the basic character of the area. So the Planning Commission, when it reviewed the application, and then the City Council, when it ruled on this, did not have evidence of either of those. The comprehensive plan designates this area as a neighborhood conservation area, which is one of 2 neighborhoods in the city where the maintenance and the integrity of existing neighborhoods are to be protected, rather than other neighborhoods where infill development is desired. So a change from the residential zoning that exists at the property would not be consistent with the comprehensive plan. Likewise, there had not been a substantial change in circumstances unanticipated by the plan affecting the basic character of the area, because when the city considered this, when it undertook its comprehensive planning process and then adopted the plan in 2013, it identified the business properties centered around this Collins Ferry and Burroughs intersection as a commercial node that should not be expanded into the neighborhood. So the zoning classification and the uses of these 2 properties to the west of the residential parcel were considered in that plan. And based on West Virginia Code 8A-7-8, the city did not have discretion to make a change in the zoning.
So you said that you need to somewhat preserve the residential nature of the community, but how does that comply with the fact that the city did allow adjacent property to the property that's at issue here to be designated as commercial?
Well, Your Honor, it's a function of the city's legislative power to establish where the boundaries between these districts go. And the Parmar Court had an excellent discussion of this. The determination made when setting a boundary between districts is a difficult one, and one that is particularly susceptible of local knowledge and community preference. So when the community conducted this 2013 comprehensive planning process, they identified this increasing commercial development in the area and identified that preserving this residential neighborhood was important. For that reason, the boundary line was maintained, and this area was designated for neighborhood preservation.
It's my understanding from the record that the adjacent property was rezoned to commercial in 2006, and I think the across the street was rezoned to commercial in 2011. And just as you represented, the comprehensive plan came in 2013. So one, am I accurate in that the two rezoning occurred prior to the comprehensive plan? And secondly, whether or not there's been any rezoning of any of the properties in that area post 2013, or has the city maintained the integrity of the comprehensive plan adopted in 2013?
That is correct, Your Honor. Both of those changes in zoning were made prior to the 2013 comprehensive plan, and the record has no indication that any other zoning amendments have been made in this residential area in the neighborhood, and I don't believe there have been any.
Is it currently R1 or is it R3?
It is currently an R1 zone, Your Honor.
So if we if we find that it shouldn't be rezoned, that the property in question is going to be bordered on the back by probably a B1 or B3 zone, where you've got the strip mall. That would be at the back of the property. And then on one side of the property, you've got clearly R3, because those are multi-family dwellings, or essentially they're townhouses down there, as I understand it. And it's going to be bordered on the other side by a church building, which is a special use permit in an R1 zone, right?
Your Honor, I think that the diagram of the area and the aerial shots in the city planner's report to the Planning Commission does an excellent job showing the uses. Those begin at 2906 of your record, and 2914 has the aerial.
I'm looking at an aerial view right now in my book, and I don't know which way is north in this one. I think I'm probably looking due east on well, Collins Ferry Road is at the bottom, and I can't read the name of the street that's at the other end, but that runs parallel to Collins Ferry. But the church is sitting there fronting. Is that Burrough Street?
Yes, Your Honor.
All right. So the church fronts on Burrough Street. Well, there's the church, then there's the lot, and then there is the strip mall with parking behind it. And then as I'm looking, I think I'm looking east, to the left are condominiums, and then you got the church. So the property in question is in between the church and those condominiums, and then bordered on the back by the commercial development, right?
I believe that's right, Your Honor. On the rear of the property from Burroughs, there is a single-family home subdivision, the homes at French Quarter Drive. And across the road from the property is another single-home subdivision. It's Vintner Place, I believe, is the name of it. And then it is bordered on the west by the mixed-use development Burroughs Place, and then it's the church property.
Right. So do you think, I mean, you've talked about Parmar, and Parmar got into, although it's really kind of strange, Parmar talks about all the factors you ought to consider and then kicks it on a procedural ground. But, I mean, they list 6 issues that are relevant factors. And do you think we ought to adopt all of those and then add to it whether or not there exists a comprehensive plan developed by the city?
Your Honor, I think that would be good policy for reviewing zoning cases, but I don't think the court needs to do that. The Anderson decision in 1964 did a very nice job of elucidating the factors that are all the factors related to the ordinance that consider the community health, safety, and welfare. And so the Anderson court didn't reference the LaSalle factors, but it said the court will consider the impact on the existing property, the impact on surrounding uses, what the surrounding zoning is, what the surrounding uses are, very similar types of qualities. I do think, Your Honor, that it's important to consider that the comprehensive plan exists because it's required by West Virginia law, and the care that went into that plan, and then how it was applied to the property where zoning is being challenged. Because the planning aspect is the building block of a rational relationship for zoning. This is how communities make decisions that are not arbitrary. And Morgantown did a very thorough job of that here on the front end with its planning process, and then took those plan concepts, integrated them into the staff report, and applied them to this property in making a presentation to the Planning Commission about whether zoning should be amended.
Going back to the comprehensive plan and adoption of 2013, it designated a neighborhood conservation area, I believe is what the term was, that included this property. Was this property a border of that neighborhood conservation plan, or is it just in the middle of it, and the other properties that we talked about are part of it as well? Or where is the border of that plan?
Your Honor, it is on one border, and that border is coterminous with the adjacent Burroughs Place business development.
Which, is that the one that fronts on Collins Ferry Road, the Burroughs Place?
I believe it fronts on Burroughs, and on Collins Ferry, right to the west of it is the Suncrest Pub.
Okay, all right. So there are 2 different properties there.
Yes, there is the Unity Manor apartment house fronts on Collins Ferry and is across the street and to the southwest.
Right. Right. Okay.
All right, I believe if you wanted to reserve time, you have about 4 to 4 minutes left, so if you want to reserve that for rebuttal.
Thank you, Mr. Chief Justice. I will take that option.
Thank you.
Good morning. Mr. Chief Justice, and may it please the court. This is a case about private property rights and government overreach. Calvary Baptist Church owns a half-acre vacant lot that's unsuitable for the residential purposes for which it's been zoned. The vacant lot has 3 strikes against it. 1, it's wedged between a large mixed-use development to the west and the church and its parking lot to the east. 2, it's located along a busy state road, Burrough Street, that's traveled by 8,000 to 10,800 cars per day. And 3, it's limited by a challenging topography that has slopes running in both a north-south and east-west direction. The city knows all of this. It extended a commercial business district right up to the vacant lot's western border because it found that the adjoining property was unlikely to ever be used for residential purposes, particularly the part fronting onto the state road. And it did much the same thing for a half-acre parcel across the street, which likewise was zoned for single-family residential. There, too, it extended a commercial business district up to that parcel's borders for essentially the same reason. The city, however, insisted on enforcing its single-family residential classification against the vacant lot, and when the church was forced to sue the city over it, the trial court found that the city's justifications were disingenuous, arbitrary and capricious at best, if not utterly misleading and manufactured. The trial court was correct on the law, it was correct on the facts, and it should be affirmed. Let me start with the law. In West Virginia, there are two cases that lay the foundation for substantive due process challenges against zoning ordinances. The first is Village of Euclid v. Ambler Realty, a 1926 U.S. Supreme Court case that upheld an Ohio village's zoning ordinance against a facial constitutional challenge. In its opinion, the U.S. Supreme Court introduced what's now known as the fairly debatable standard of review. Under that standard, if the validity of the legislative classification for zoning purposes be fairly debatable, the legislative judgment must be allowed to control. The second is Carter v. City of Bluefield, a 1949 decision from the court that adopted Village of Euclid and the fairly debatable standard into West Virginia law. Now, in its petition, the city seems to say that the trial court did not apply that fairly debatable standard because the phrase does not appear in the court's opinion. But the U.S. Supreme Court has held in another constitutional context, the habeas context, that a trial court is presumed to have applied the correct legal standard when the record is otherwise silent. And here there's no need for a presumption, because the trial court cited both the Village of Euclid and Carter cases from which the fairly debatable standard originates. The trial court got it right. The city then seems to say that if the trial court applied the fairly debatable standard, it nonetheless failed to take all the relevant factors into account. This comes to the question that Justice Hutchison asked about the factors that should be applied here and which factors the city's advancing. According to the city, there are 9 factors. All of them come from decisions of the Supreme Court of Illinois. 6 come from a 1957 case called LaSalle National Bank v. County of Cook, and 3 come from a 1960 case called Sinclair Pipeline v. Village of Rickton. Only 6 of those factors have been recognized in West Virginia law. In its 1990 Parmar case, this court adopted the 6 factors from the LaSalle case. It did not adopt the 3 factors from the Sinclair Pipeline case, even though those factors had been in existence at that time for 30 years. The trial court here quoted each of the 6 factors that this court adopted in Parmar, and it applied them. That it did not apply the 3 Sinclair Pipeline factors from Illinois law, which this court chose not to adopt, can hardly qualify as an error. Here, too, the trial court got it right. City next argues that even if the trial court applied the correct legal standard, it erred by considering evidence relating to its decision to rezone 2 adjacent properties from single-family residential to commercial business. The city bears a heavy burden on this argument. A trial court's decision whether to admit or to exclude evidence is reviewed for abuse of discretion. And here, there are at least 2 reasons why the trial court was right to consider the city's past zoning decisions. First, the fact that the city rezoned 2 adjacent properties from residential to commercial tends to show that the neighborhood is experiencing a commercial trend. This court found that a commercial trend was relevant to the constitutional analysis in 2 of its earliest decisions, Carter and Anderson, and it incorporated that commercial trend as part of its consideration under the 6th factor in Parmar. Second, the city's reasons for changing the zoning for adjacent properties from residential to commercial tends to show whether residential zoning for the vacant lot is both suitable and promotive of the public welfare, 2 of the factors that this court has instructed trial courts to consider under Parmar. This court also recognized in Carter that it can hardly be injurious to the public welfare for a property owner to use his property in the same manner as his neighbor. And so why the city found that the public welfare permitted commercial uses for the vacant lot's neighbors informs whether those same uses are appropriate here for the vacant lot. Once again, the trial court got it right by considering this evidence.
Counsel, can I ask you a question on that point? Because we talked a little bit about the border of this neighborhood zone, and so, yeah, I mean, I think there's a strong argument that the fact that the adjacent property has been zoned from a business perspective is persuasive, but at the same time, doesn't the city have the ability to draw a line at some point to say this property past this line will not be zoned commercially? So what is their authority to do that, to sort of draw that line?
Well, the city does have authority to draw a line. Our point here is that the line is not appropriate where they've drawn it. That the line drawing must have some substantial relation to the public welfare. And there I depart from what the city's attorney said, which is that it must simply have a rational basis, a rational connection, because the case law is stronger. It says it must bear a substantial relation to the public welfare. So if the city has chosen to draw a line in a location that's arbitrary or unreasonable, or fails to bear that relation to the public welfare, then its decision cannot stand. And that's the point we made here, and that the trial court found that we'd made. But the second thing, and I want to return to Parmar, because it's the Parmar court that talked about line drawing. And I think it's interesting what the holdings from the Parmar cases were, and particularly the cases that it cited, because all of them indicate that the line was drawn along a natural border or a street or a road. And that's not the case here. The line is drawn in the middle of a city block. And so I think that there is less weight that should be given to the city's determination in that case, because there is no natural border. There's no natural separation between the B2 zoning district and the R1 zoning district that applies to the vacant lot. In fact, because of what the city did in its past zoning decisions, the vacant lot has a 2-story commercial building that runs most of the length of the north-south boundary within 10 feet of the border.
Is there, from my look at it, there's no road or, as you would no separation between that property of Calvary that's the kind of rectangular and the commercial property. Between the commercial property and the property of Calvary that's at issue here, there's not an alley or a street or anything there, is there?
No, Justice Jenkins, they're touching.
They're touching. There's some trees there. It's a sloped ground. You got the road on the bottom. You've got some of the houses on the top. Calvary, as I envision it.
So if you were to turn onto Burrow Street from Collins Ferry Road, you would pass the Suncrest. Well, first you drive past Slight Indulgence and the Suncrest Pub on Wen, and both of those properties are zoned for B2. You would look across the street and you would see the Unity House development, which is about a 5-story multifamily development. Both of those are at the corner at the intersection of Burrow Street and Collins Ferry Road. And as you turn down Burrow Street, you would quickly run into the Burroughs Place development, which is a large mixed-use development. It's horseshoe-shaped. On either side, running north to south, are two-story commercial buildings that have a number of commercial tenants. And then in the rear, you have a 5-story apartment building that looks down both on the parking lot and looks down on the side on this vacant lot from the upper stories.
I've kind of lost track of if you're coming down the commercial property, the land at issue, and then the church. If you continue on that road in that direction, what is the next block over? Is that a single family? Because I assume that's in the comprehensive plan and is zoned residential.
The next 3 blocks are zoned for residential, and then you run into another commercial district that's at the end of Burrow Street at its intersection with West Virginia 705.
And it may be improper to ask, but my sense is what you're suggesting is if the comprehensive plan had drawn the line at the other side of Calvary Church and made it residential as it is, that's fine. The problem is that the line is drawn between the Calvary property and the commercial.
Well, I think that our position would be that the comprehensive plan does not inform on the constitutional analysis, that it's at most a 30,000-foot view, and the constitutional analysis here must look at the property and the zoning ordinance as it applies on the ground. And the comprehensive plan doesn't bear on that question. It might have some weight as it relates to a facial challenge, but that's not what we have here. The fact that the city has planned for this unconstitutional result doesn't mean that it's any better. And so what we would look at is what the character is like actually on the ground. And again, here we have a property that's wedged between two non-residential uses. We have the large Burroughs Place development to the west. We have the church and its parking lot to the east. To the south, we have Burroughs Street, where 8,000 to 10,800 vehicles travel a day. And we have the wine bar, Catter Corner, across the street. If you look at the residential properties in this area, and you will see, and the record reflects, that a couple things are true. First, most of them are older. The properties that the city mentioned, both at trial and here today, were mostly built more than 10 years ago. Most of them were built on side streets. They don't have direct access to Burroughs. Of those that are built on the side streets, many of them are also separated from the road by privacy fences or some type of orientation. Bernie Bossio, who developed most of those properties, as he testified at trial, made a conscious decision to do so because of the impact on residential development from the location along Burroughs Street. The thing that I think is most important about the city's statement in its 2003 rezoning for the B2 property next door is that the city found at the time that it was unlikely there would be residential development on that property, particularly the part along Burroughs Street. And when we looked at the trial evidence, the city's prediction was true. It came true. Of those properties, in the last 20 years, only one had been built that fronted onto Burroughs Street. And that property was located 100 to 200 feet back from the street. There's every indication that, much like Carter, where there was only one residential property that had been built in the last 25 years, the frontage onto Burroughs Street, the only way that a residential property could be built on this vacant lot owned by the church, is not suitable for residential development.
It has access to the cross street. You've got Burroughs going back, and there's a cross street. What's the next cross street back?
The next cross street is Eastern Avenue, Justice Hutchison, and it doesn't have access to Eastern Avenue. And the reason is because there is a stormwater basin in the rear that blocks access if you were to run a road along the fence line from Eastern Avenue to that vacant lot. The only way that you would be able to access the vacant lot any other way from Burroughs Street would be to drive across the church parking lot. And I think we don't need explicit testimony to understand why that is not an attractive situation for residential development.
If there's no access from Eastern, where's the access going to come for this commercial development?
Well, the commercial development would have to access onto Burroughs Street as well. But the different...
They'd have to drive across the parking lot.
Excuse me, I didn't hear the question.
They would have to drive across the parking lot as well then, if they're going to access it from Burroughs Street.
No, there's 80 feet of frontage onto Burroughs Street, so you could have an entry and exit from this property onto Burroughs Street.
And that same entry and exit could be used for a residential development.
It could, but the difference there is that, as our appraiser testified at trial, the residential real estate market is one of the most sensitive in all of real estate. And though, as the city's attorney has pointed out, he also said that the Suncrest neighborhood is relatively desirable. When he looked at the conditions on the ground, which again is where the trial court's analysis had to be in an as-applied challenge like this, he found that there were significant detriments against this property for residential use because of those factors, because of those access factors, the street factors, the privacy implications from the 5-story commercial developments to the west and the church and its parking lot to the east. And they reduced the value of this property by 40%. It's the $140,000 diminution in value that we have under this zoning application. And the inquiry, or part of the inquiry, is whether that loss to the church is justified by the promotion of the public health, safety, morals, or general welfare. And the evidence at trial was that it was not. That for this half-acre parcel, it could be put to a commercial use without impacting the surrounding residential properties or the overall character of the neighborhood.
Was there evidence in the record, or maybe I'll just ask the question, wasn't there a time where, and maybe it still happens, that people using the adjacent or nearby commercial businesses would park in the church parking lot?
It's not in the record, Your Honor, but yes, that's true. So, if we go to the factors that this court the trial court was required to consider under this court's Parmar decision. There are 6. Broadly, they all seek to consider the public gain from the zoning classification as opposed to the private harm. But to paraphrase slightly, they are this. 1, the zoning and uses of nearby property. 2, the impact of the residential zoning on the vacant lot's property values. 3, whether the lost property value promotes the public welfare. 4, the relative gain to the public from the residential zoning in comparison to the harm to the church. 5, the suitability of the vacant lot for the residential use. And 6, the length of time the vacant lot has remained vacant under residential zoning as compared to development trends in the area. The church met its burden on each of those factors, showed that nearby properties were already being used for commercial and other non-residential uses. For instance, starting from the vacant lot's western border, both sides of Borough Street had been zoned for some type of commercial use. Showed that the residential properties identified by the city had nearly all been constructed at least 10 years earlier and were separated by Borough Street from some combination of side street access, orientation, or privacy fencing. Again, only one house in the last 20 years had been built fronting onto Borough Street, and even then it was set 100 to 200 feet back from the road.
And that house has a fence around it, doesn't it?
That church, yes, that house has a fence around it. In fact, it's in the record. It's owned by WU basketball coach Bob Huggins. And so I think what that also shows, again, is the difficulty of locating a house in a way that where your access has to come from Borough Street, which is what would be required here. And again, the church showed that this is exactly what the city had predicted when it rezoned the property next door in 2003 and then rezoned it in 2006, that it was unlikely that new residential development would take place when it fronted onto Borough Street. Church also showed that the residential zoning had a $140,000 impact on the vacant lot's property value, dropping it from $268,000 under commercial zoning to $128,000 under residential zoning. Showed that this loss failed to promote the public welfare, let alone outweigh the harm that the church would experience. Nearby properties like Burroughs Place, the Wine Bar, Suncrest Pub, the Slight Indulgent Specialty Food Store were already being used as commercial properties, and the vacant lot's small size, slightly less than 1/2 acre, limited its ability to be put to more intense uses. By contrast, any house built on that vacant lot would front onto Borough Street with its 8,000 to 10,800 vehicular trips per day. Headlights from vehicles using both the Burroughs Place and church parking lots would shine onto the property. Residents in the 5-story Burroughs Place apartments would look down on it, as would tenants in the 2-story commercial building that runs along the length of its north-south boundary. And all of that assumed that a residential developer could bear the costs of accounting for a difficult topography with slopes that run from the north to the south and east to the west. No one disputed that it was theoretically possible to build a home on that property, but everyone who was asked thought it unlikely. The church further showed that the trend for nearby properties was toward commercial development. And again, it showed that the city had made zoning decisions that placed the church in this predicament, bringing commercial uses, B2 uses, up to its very doorstep. Finally, the church showed that it had twice asked the city to change the vacant lot zoning, once before filing suit and once while the suit was pending. It showed that when in evaluating the second application, the city had made previously favorable findings neutral and previously neutral findings negative, for no other apparent reason than that the church had filed suit. And I want to stop here because the city said that the enforcement of its application plan results in a rational decision. But what the record showed and what the trial court had available to it in making its decision is that after the city filed suit, the city planner performed another evaluation for our second application in which the city planner changed factors from negative to positive, from positive to neutral and from neutral to negative, and omitted information that was highly relevant to our application. For example, and this starts at page 3404 of the record. The city planner removed out reference to a corridor enhancement area that runs along the Borough Street corridor and that promotes the idea of infill development and more intensive uses. The city planner took out reference to the non-residential development to the west when evaluating the factors under the comprehensive plan. The city took out reference to the adjoining property zoning being for B2, commercial business purposes. And the city planners took out reference to the amendment promoting corridor development. These weren't things that the city planner failed to mention or overlooked. These were things that the city planner deliberately took out while this litigation was pending.
Council, I believe your
Yes.
time has expired, so I would ask that you...
Yes. As I said at the start, the trial court did not consider this to have been a particularly close call. It found that the city's justifications were disingenuous, not utterly misleading and manufactured. The trial court got it right, and we ask this court to affirm. Thank you.
Thank you, Your Honor. I'd like to address a couple housekeeping matters on the record that I think really point out the value of the fairly debatable standard. Respondents' counsel stated that there is traffic on this road between 8,000 and 10,800 cars per day. And I'll tell you, the traffic counts in the records show that from 2011 to 2017, the years for which we have data, the traffic trend is downward. The last year was below 8,000 cars per day, although there was a slight uptick in that count. And this and the other three items I'm going to mention all show that there are positive and negative factors to zoning. High traffic can be a difficult thing for residential development, and building a new commercial development can drive traffic to an area that's residential and impact the quality of life for people who live there, as Mr. Fletcher testified at trial. Respondents' counsel noted that there's challenging topography at the site, and that's the case, as testified by Respondent's appraiser. He priced in that challenging topography for both commercial value and for residential value. He ranked site utility as 60% and reduced value accordingly. So when we talk about the appraised value of the site for residential and commercial value, those are all priced in. All these negative characteristics, the appraiser looked at those. He said this property with residential zoning, someone will probably buy it for $128,000. And in this market, in this neighborhood, these places usually sell in 3 to 6 months. It shows substantial value for residential use. Admittedly, there's an appraised higher sale value for commercial use. This just shows that under the fairly debatable standard, we have positive and negative factors to zoning, and this is a use properly within the legislative power of local land use planners and elected representatives.
Did opposing counsel correctly categorize the change in certain factors made after this litigation was commenced?
Your Honor, I think that some of those factors may have been misstated, particularly with reference to the corridor enhancement character area within the city's comprehensive plan. This is an area in the Chapter 3, the land use planning section of the plan, and where it occurs in the plan, there's an asterisk and says this is something like an overlay. It's a part of other districts. It does not end the boundaries of other districts. The recommendation or the review of that corridor was changed by the planning staff from the 2016 staff report to the 2018 staff report, which was required when the circuit court ordered the respondent to apply again for a zoning amendment. It did that and made these other changes, as Mr. Fletcher testified, in response to the respondent's claims that the planning staff had failed to address characteristics relevant to the property. And I understand that the respondent disagrees with the findings that the planning staff made when it went back and reviewed those characteristics, but Mr. Fletcher's testimony was that he did this in an effort to address the things raised by the respondent that they believed had not been properly addressed and were relevant to the planning decision. So the final matter I wanted to address was the 2003 zoning amendment for Burroughs Place. The staff report in the record made clear this is a correction of a mapping error. This property was a B1 district since the city has had zoning. There was a barber shop and a parking lot on it, and as well as a trailer park. When a new purchaser bought it for development, they discovered that approximately 60 feet of 3 parcels on the eastern side wasn't indicated as B1 on the map, the planning staff recommended to the city council that the map be corrected, and that was done. The reason cited, I believe, in that staff report was for the lack of likely residential development was that there's an existing parking lot with a barber shop. So briefly, I wanted to address the argument that a permissible boundary is a street and not anywhere other than a street. I think that invites the court to dig into these local land use planning decisions and that it doesn't have a stopping point. If the court's rule is that only these street boundaries can form the boundaries between zoning districts, and it grants relief in this case, the next property over is likely to seek that relief as well, because, as we know, planning does have the tendency to reduce market value for certain properties, but it provides a benefit to the community as a whole. And that's the reason for committing it as a legislative power and preserving this court's role in making constitutional decisions. I'd ask the court to consider that the fairly debatable standard does that this case presents many positive and some negative factors relative to the residential zoning classification in the Suncrest neighborhood, and I would ask that the court overturn the circuit court ruling and order that Morgantown's zoning classification be upheld. Thank you.
Thank you. You're both very good arguments. This case will be submitted. Thank you.
Where's Huggins' house? This is first.
The court will now turn to the Rule 19 oral argument docket. Lawyer Disciplinary Board versus E. LaVoyd Morgan, Jr., docket number 190879. This is a lawyer disciplinary case, and like I said, being argued under Rule 19. So each side of the argument will be given 10 minutes for oral argument. I will let counsel know that although Justice Workman is not here in the courtroom at this time, she is participating by viewing and listening to the oral argument, and she will participate in the decision and opinion in this case. With that, counsel for the petitioner may proceed.
May it please this honorable court, Chief Justice Armstead and justices. I am Jessica Donahue Rhodes, Lawyer Disciplinary Counsel for the Office of Lawyer Disciplinary Counsel. I am here before the court today after Mr. Morgan objected to the recommendation of the hearing panel subcommittee that he be disbarred. I am here to support the recommendation of the hearing panel subcommittee that he be disbarred, along with other sanctions, including refunding just over $40,000 to various clients and to the public defender services, paying the judgment plus interest to a former employee, complying with Rule 3.28 of the Rules of Lawyer Disciplinary Procedure, and paying cost of the proceedings. The first thing I'd like to point out in this case, Mr. Morgan's own testimony at the hearing in this matter, wherein he admitted to lack of communication, lack of diligence, lack of written fee agreements, lack of settlement statements, commingling of money, improper use of an escrow trust account as being problems for him. And he also admitted that lack of time records in office and an office management system were issues for him. He was charged in a statement of charges that included 22 separate complaints that were filed against him. That resulted in 134 rule violations that were found by the hearing panel subcommittee, and that was involving 19 different rules of the rules of professional conduct. The first case involved his overbilling to the public defender services. He admitted to billing 6.1 hours as paralegal time of his own and billing 5.5 hours of duplicate travel time. He further admitted to overbilling 5.4 hours, and when confronted with a day that totaled 28.8 hours of billable time, he said he could not explain the additional 9.5 hours and indicated that that should be reimbursed to the public defender services. The second case involved a criminal client wherein he was retained to represent that client and was paid $8,000 for that representation. He never sent a client file to the client after being disengaged from representing and failed to refund the unearned portion of that retainer. There was testimony in this case that the billing provided by the respondent for earnings that in the case was actually falsified. The former employee said she heard Mr. Morgan tell an employee to make the billing cover what we need to for the cost. Further, one of the most serious issues here with Mr. Morgan in this case was the money that he was supposed to be holding for the client was not in the trust account. It was in a negative balance 2 months after the $8,000 was paid. And if you look at his assertion that he earned $2,000 of that, then there should have been at least $6,000 in that trust account. It went into a negative balance after representing Mr. Norwood. He then represented two clients, Lori Ann McKinney and Richard McKinney, in their criminal case. While they were being represented by him, they sought his representation for a medical malpractice case in Kentucky. He failed to properly investigate that and failed to inform them that he could not handle that, which resulted in them missing the statute of limitations in Kentucky, which is only a year. Further, there was testimony from several of his former employees and these clients that the plea agreement was went over with by an employee of the office and not Mr. Morgan. There was another client, Wanda Tallman. She paid Mr. Morgan for representation of her granddaughter. He never provided the client file, and again, the IOLTA account did not show when the retainer was deposited, and the next month after it was paid, the IOLTA account was in a negative balance. He also failed to respond to 2 letters from the Office of Disciplinary Counsel in that matter. He then represented Evelyn Lewis, and again, there was no communication by him. There was no itemization of the work he performed. He did not provide the client file to her, and it was unclear from the IOLTA account whether the retainer was deposited in that account, but by the end of the next month, again, the IOLTA account was in the negative balance. He represented Todd Clutter and his wife Jacqueline, and he was paid for 4 cases. He didn't appear at a hearing. He failed to communicate with them, and the IOLTA account again did not show the retainer being deposited in that account, and by the end of the month, that account was in the negative. A review of his operating account showed that the retainer checks were deposited into the operating account. He also failed to respond to a letter from the Office of Disciplinary Counsel. And I've got various other cases.
Well, and maybe that's where I was going to go. Obviously, in the Battistelli case was the first time this court took up the issue of this extraordinary circumstance. Would you maybe just compare and contrast under that standard set forth by this court why this matter meets that standard?
Are you talking about the repayment of funds or the absent extenuating circumstances?
Well, it's, in any respect, this course, I understand, under that decision was really the first time under Rule 3.27, set forth the extraordinary circumstances by which taking the step to suspend or to annul the license would be justified. And I'm interested in you comparing and contrasting this case circumstances to that criteria set forth by the court.
Well, in Battistelli, in that case, an expert was failed. The attorney did not pay the expert in that, and he obtained a $10,000 loan from a client and failed to file a response to a motion to dismiss for 6 years. In this case, we have a clear indication that Mr. Morgan failed to properly handle client funds. He failed to safekeep them. We have various accounts. We even have a settlement check that was deposited into the IOLTA account, And again, while it should have been in that IOLTA account, it went into the negative balance. During that time frame, there was testimony that only Mr. Morgan had control over that IOLTA account, and the only time funds were taken out, he was the only person allowed to sign checks, and he would tell his wife, who was his office manager, to transfer funds from the IOLTA account into the operating account. I think there's a clear difference here. I don't believe there is any extenuating circumstances here that would prevent his disbarment in this matter. I know he talks about an employee that took money from him, but if you look at the evidence in this case, 10 clients gave him money, and that money was missing before this client took over the running of the office. The client, before the employee took over running of the office. This employee took over running in August of 2017. The July 2017 IOLTA account bank record clearly shows it was in a negative balance, and again, 10 clients had their money missing from that account. So his attempt to put this blame on the employee does not meet the extenuating circumstances. It shows that it was his responsibility. It was his failure to keep that. And then even putting an employee in control of your trust account, it is still your responsibility to safekeep those funds. He chose not to look at bank statements. He chose not to look at the bank account in any way. And in fact, the time that he discovered that his IOLTA account was in a negative balance was when I showed him the bank statement at his sworn statement at our office almost a year later, or several months later.
He contended he had some health issues. Did those predate the time that the employee started taking care of things, or were his physical issues after that? I mean, I'm trying to figure out whether or not there's a claim that his physical illnesses would be a mitigating factor.
There was testimony that he was unable to come into the office, and he ended up having surgery in May of 2018. But again, the missing money from the IOLTA account was again in the negative in July of 2017. And I believe there was no evidence that showed he was unable to open bank statements. And in fact, he reported that employee to the police for embezzlement in January of 2018. And when he was going to be out of the office for the surgery, he chose that employee in May of 2018, just 5 months after he reported him to the police for embezzlement, to control his office. So there was just a complete disregard of protecting clients in this matter. I don't believe, and when you look at the other instances, the failure to communicate, the failure to provide client files, there's various clients that never got their client file back from him. There was failure to refund those fees. There was also a situation where his law office is named Lavoie Morgan and Associates, and he does not have another associate in that office. So that is another violation of the rules. He committed criminal acts with the worthless check paid to an employee who took him filing a charge in magistrate court in order to get that paid, and it took almost a year after that. So I believe the evidence in this case is clear that he did convert and misappropriate client funds, and there's no extenuating circumstances to excuse this, and he should be disbarred. And again, as I said earlier, this is 134 different rule violations that were found by the hearing panel. I've never dealt with a case with that many rule violations, and it involved 19 different rules. This isn't just a one-off occasion where he was sick and couldn't go into the office. This is an overreaching thing involved in his office, that he failed to properly run his office, and therefore he failed to properly represent his clients and failed to protect their interests in this matter, and I believe he should be disbarred.
Thank you.
is Lonnie Simmons. I represent Mr. Morgan. I have my work cut out for me this morning. When I was here before and they used the quickie procedure to get him suspended, it wasn't successful there. So as of this point, Mr. Morgan has been suspended from the practice of law for 5 months. I think the thing I wanted to focus on, I've mentioned, of course, even though your case law says there's nothing wrong with verbatim adoption of orders, I've never seen such an extreme example, 158-page order adopted verbatim. I know that means you still have to look at the merits of it. It doesn't matter who did it. But the thing that sort of jumps out at me when I look at the order is when the hearing panel makes conclusions, very specific conclusions about things that Mr. Morgan didn't do with respect to, and I think the best example is count 9. He never met these people. These were people who only met, and we keep talking to this paralegal that he hired, never met these people at all. So, but the hearing panel makes findings. Well, he failed to do this. He failed to do that. He failed to, well, I mean, it's to me that's an example of why the verbatim adoption of such a long order with 495 findings of fact was at least suspect here, and that's why I would ask the court to look at it. The things I would like to focus on, let's talk about the paralegal. This is an issue that this court has not yet addressed specifically, is, well, what happens when a law firm has an employee who, in this case, he put one of those square things on his iPhone. He took money directly from clients, and Mr. Morgan had no idea about it. So money was going directly to the paralegal that never made it into his account. And in 100%, Mr. Morgan he owes that client money. That was his employee, that was his agent. No, we don't dispute that at all. But to further penalize and find all these other violations with respect to employees that he doesn't even know, I think is unfair.
Mr. Simmons, if
yes.
we were to take away, give you the benefit of the doubt that the paralegal was a thief and a crook and all that, we take all of that away, what have we got left?
It reduces the number some. I understand what you're saying. I might even get it below 20. I might get below 20 there, okay, so, which is a start. And then I'll go into my next argument. Under your case law, you categorize the act of the lawyer as negligent, knowing, or intentional. My view and the argument and the evidence we presented was everything was negligent. He actually had for a solo practitioner, he actually had maybe an overly successful law firm. He had lots and lots of clients. But if you're a solo practitioner, you're relying on your staff. You're jumping around from magistrate court to circuit court to family court. You're in this county, that county, that county. You're not in the office every day. You 100% have to rely on your staff. He relied on his wife to handle the money. Yes, he was negligent. Should have read the bank statement. Should have checked where the money was going. Should have made sure the money went into the out account. All that, 100%. But you have decided cases. You actually have cases going both ways. You have some cases that say when money isn't placed properly in the IOTA and that sort of thing, that's the end of the world. Annul the license. You have cases that say that. You also have cases, Adkins and Santa Barbara, and there's another case that was cited therein, when the lawyer is relying on the staff to do that, negligence, no doubt about that, but you're not as harsh. You actually have suspended people's licenses when that has occurred. So I think those cases, I think, are extremely relevant here. And again, when we went through this thing, he's acknowledging all these things. We're not disputing those things. It's just a matter, at least from my view of your cases, if the lawyer is negligent as opposed to doing something intentional, there should be, as you weigh things out, the court should lean more toward a suspension as opposed to an annulment when, so many of your annulment cases are where someone's committed some, crime and stolen money from clients and that sort of thing. let's talk about the health situation. There's a lot of communications issues in this case, no question about that. When you look at the file, you will see that from about December of 2017 through about July or August of 2018, that was the period of time when he couldn't climb the 23 steps into his office. He had to meet people outside his office. That's what his testimony was. And then when he's in the hospital, it's like the day he's in the hospital is when the paralegal who was running the office was arrested for a crime. So there wasn't anybody there. So there's letters, there's phone calls. You're right, clients had the right to be upset. Yeah, they're not getting any return to them. But he was in the hospital then. And so a lot of the communications issues are actually during that time. And I didn't feel like that the hearing panel gave enough weight to that when they were going through it. There were a lot of letters from the ODC that apparently weren't responded to. Now, this is a case where there wasn't just one letter per complaint. There were multiple letters per complaint. So there were responses filed to every single complaint. It's just that there were some that either he missed, and it even came out that some of them were sent to me or my office, or supposedly sent to my office, and we usually scan it in, we mark the 20 days down, and we respond. Well, he shouldn't be held responsible for a letter that I missed. I still haven't seen those letters, but according to what's in the file, there are letters there that were addressed to me to respond to, and that didn't happen. So I don't think he should be penalized for that. And I mean, I just think I know I laid it on a little thick in the brief. I tried to lay it out the best I could. I do think he is a lawyer who deserves some encouragement. I could see him, if you saw fit, to give him a suspension instead of annulment. Have supervised practice, any other condition that you all would think would be appropriate. But he worked really, really hard to get his law degree. It means a lot to him. I think he needs some hope from the court so that he can work toward getting it back. And so I think that, unless you have any questions, I think that's what I wanted to say.
I just have one question, and what is there in the record in terms of evidence of things that this lawyer has done to improve himself, to remedy the things that, even to take your characterization, were negligent? Is there any evidence in the record that would give us the hope that you're asking us to have?
In his testimony, there were more folks, more clients than just the ones in this case who paid money directly to the paralegal. He got approached in a store. He got approached, Lewisburg is a small town, right? And his testimony was, in some cases, he provided pro bono work for them. In one case, he came up with a payment plan to pay him back. So there were certain people who knew him real well, and they understood the circumstances, and they were willing to work with him, and that's what happened. That's probably the main thing that's in the record on that issue.
Thank you.
All right.
Thank you.
Thank you. Thank you.
I just have a few notes. First of all, this employee, if you read, especially regarding Mr. Norwood, when Mr. Norwood contacted Mr. Morgan about representing him, who visited in jail to go over that potential representation? That was the employee. The employee had authority to go and talk to clients and talk to them about cases. There was evidence in this case that happened. So he wasn't going beyond what Mr. Morgan expected of him. Further, regarding this Square account that money was paid to, it wasn't paid to Mr. Morgan, but if you look at count 20, that involved the client for divorce. He testified he went to the law office and gave them his credit card, and he didn't know what they did behind the scenes or in the office beyond there. He actually went to his law office, Mr. Morgan's law office, and that's where the account was paid from. I believe Mr. Morgan's misconduct in this was intentional. He chose not to instruct his staff onto how to run these trust accounts. He chose not to review his bank statements. He intentionally chose this course of action. Perhaps if an employee misappropriated funds and you discover it the next month and you fire that employee and take steps to rectify that situation, perhaps that would be a situation here. With Mr. Morgan, he not only chose not to fire that employee when he reported him for embezzlement, but if you look at the evidence, his own wife told him about a year before he allowed this employee to take over, "I think he's taken money from the firm." He did nothing. The employee takes over. He then discovers that he perhaps embezzled money, reports him to the police, and again, still does not fire this employee, but chooses to have him control his law office when he's out for a medical procedure. If that isn't intentional, I don't know what is. It is clear he intentionally did this. I don't think it's an excuse or a defense for an attorney to just bury their head in the sand and then say, whoops, it's negligence. I don't have to take any responsibility in this. Further, the issues with the letters not responding to the Office of Disciplinary Counsel, he did ultimately respond, but there were several letters we had to send. He was not charged with not sending letters. The letters that went to Mr. Simmons, he was not charged with not responding to those. And again, I think the evidence shows that he misappropriated and converted client funds, along with the lack of communication, lack of diligence, the failure to get written fee agreements, stuff like that clearly shows he should be disbarred, and I believe there's no compelling circumstances to not disbar him in this case.
Thank you. This case will be submitted.
Thank you.